And now I'm being joined by a legal practitioner, Mr. Vincent Ottaokpukpu, to discuss this matter of the former Minister of Labour and Employment. Thank you for joining us.
Thank you for having me.
Mr. Ottaokpukpu, I mean, this is not the first time a former minister, a former governor has been taken to court by the EFCC for contract fraud. But what's the difference with this one?
The difference is probably he was arrested 2 days ago on the 10th, and today he's charged to court. That means there's every presumption or presupposition that they may have concluded the investigation. The reason why they have taken him to court, because once arraignment is done, the formal charge has been filed, which activates the arraignment of a defendant or suspect before the court. And once that charge is read, the plea of guilty or not guilty is taken. And once that is taken, that activates the jurisdiction of the court to go into the full trial. So to this arraignment today, the arrest was done a few days ago, and today they are already in court. The EFCC has power to prosecute, to arrest, to prosecute, and to investigate crime, financial crime, under Section 6B, Section 7, 2A, and F of the EFCC Act. They have the general power to investigate, to even prevent financial crime, investigate financial crime, even to prosecute. They have prosecutorial power under Section 13, Sub 2, even the establishment of legal department and prosecution unit in their department, as the case may be. So the power to, when persons are suspected to have committed a financial crime, they're just an accused person. Every other person can be accused for committing an offense. And the power to charge reside in EFCC. Power to prosecute reside in EFCC. Very many sections of the EFCC Act have cited. But you must remember that Section 636 of the Constitution guarantees every person charged with a criminal offense the presumption of innocence.
Yes.
That the person who is charged with offense is presumed to be innocent until contrary is proved. So as it were, he's still presumed to be innocent.
And we do know that he pleaded not guilty to this crime, but yet the court is, the prosecution is afraid that he's a flight risk.
Yes. Now, once a plea has been taken, guilty or not guilty, once not guilty is pleaded, then if the offense is a available offense, the court will consider the issue of bail. And what I learned today is that there's an application for bail pending or something, and the prosecution needed to respond to it. It's a court of record. The court cannot take oral application to grant bail or release on bail just like that. It must come by a formal application before the court, serve on the other side, and which they must have responded.
Let's look at this matter of flight risk. The last time we understand that his passport was released to him so that he could travel abroad for medical attention. Okay. Now, we know that there is the immigration. He cannot go out of the country without the immigration stamping his passport unless he is smuggled out.
Yes.
Now, he is also in the court. The report has it that he had explained to the court that his passport is not with him, but with one of the embassies where he's seeking a visa to travel. In that kind of situation, couldn't the court have said, okay, you can go, knowing that the immigration service is on ground to ensure he does not leave this country? Does that not point to the fact that there might be a bit of conspiracy in the other agencies that are supposed to be working the EFCC to fight corruption?
Yes, by the provision of Section 158 of the Administration of Criminal Justice Act, because arraignment and criminal prosecution by EFCC and the police or Attorney General Office is regulated by the Constitution and the Administration of Criminal Justice Act, which is a procedural law that applies to proceedings in criminal matters. Now, the court has powers, ample powers and opportunity under Section 158 to grant bail. Part of what the court considered in granting bail are one of the reasons of what you have mentioned now, the opportunity of the persons not to tamper with investigation or even investigation or tamper with prosecution witnesses or destroy evidence that will be used against him, or even abscond. That is the possibility of the persons to be able to stand trial, to take his trial, as the case may be. Now, the passport issued by Nigerian immigration to a private citizen of Nigeria. You remember the case of Orisaba versus DSS, which the Supreme Court have emphasized. He was arrested traveling to under the military regime, attend the conference at The Hague. He was arrested at the Murtala Mohammed Airport and his passport was taken. Supreme Court held, despite the inscription at the back of the passport that it belongs to the federal government, it is a citizen's property, even though it belongs to the federal government, but it belongs to a citizen, and which is with right of ingress and egress. So the court considered these are issues the court will take, and there's no need for us to preempt the court at the case may be. But if the passport is with an agency of government, as the case may be, there's a way EFCC will write to the agency to confirm that the passport is with them, number one. Then if that constitutes part of the condition the court will grant, because if the court considers his bail, because under the EFCC Act, all the offenses listed there are bailable offenses.
I was going to go there. So, but in this case now that the court has decided to remand him, would you say that remand is justifiable?
Yes. After arraignment, the court, once a suspect or defendant has been arraigned before the court, the court takes over after arraignment.
I wanted you to answer the question. Okay, just get to it. Would you say this remand is justifiable? Because I was going somewhere.
The remand is justifiable in law.
All right.
Because the court couldn't have ordered him to be remanded in EFCC custody, because once he has been arraigned, the court takes over proceedings and the release or detention of the suspect or defendant under trial. It's no more going to be remanded in any other facility or except that of the court. If they want to remand him under their facility, EFCC, they can apply to a magistrate under section 293 of the ACTA, which the magistrate can grant them for detention under 14 days. But that cannot apply again, because that is when they are still doing investigation. But having filed a formal charge and arraignment has been taken and plea taken, every business of that proceedings, release and detention must be handled by the court where the accused person is standing trial.
Okay, so this question here, well, let me just link it to something that happened in the National Assembly yesterday, where a former public officer, an aide to a former president, was asked to take a bow, and not many questions. In fact, he wasn't asked any question. Mm-hmm. That's not the first time that's happened in the National Assembly. They say because we recognize him.
Yes.
This man, Dr. Ngige, was a governor, was a minister, was a public figure. One would think that, having been, he would be treated as one that is recognizable and one that can be standing in his own stead as a public figure. Do you think that is also having any effect on the way the court or the prosecution is treating this case?
No, in the final analysis, when the formal application for bail has been argued, is formally argued, and the court takes over to deliver ruling, the prosecutor must have may oppose or may not oppose. In most likely cases, they will oppose. Now, the court will take into consideration from the Ngige's lawyer, for what I learned today, that he was a former governor from 2003 to 2006. He was a former minister from 2015 to 2023. So this court will take into, because the counsel was arguing that he should be granted bail in most lenient term under self-recognition. He must be recognized as a public figure under self-recognition. That is to waive the requirement of getting shorty 16 at the grade 16 grade level of civil servant, permanent secretary. Those requirements that should be waived because of his personality involved as a former governor. He will not be able to run. He will be able to stand trial to take it. So, but in the final analysis, these are the condition and terms of condition, and the court will consider in granting bail. And it won't be good for us to sit down here and preempt the court, what the court will do and what court will not do.
Thank you very much. Vincent Ottaokpukpu is a legal practitioner. Thank you for coming in this evening.
Thank you for having me.